Many people have been asking me about what is going on with the Missouri Second Amendment Preservation Act that went before the U.S. Supreme Court a couple months ago, and the Supreme Court refused to hear the question about whether or not it's constitutional in light of an Eighth Circuit Court of Appeals ruling that said that the Missouri law was unconstitutional under, among other things, the Federal Supremacy Clause. So I'm just going to walk you through some of the questions involved with this Missouri law and whether or not we should have been surprised that the U.S. Supreme Court did not take this case, and maybe how can Missouri fix it in a favorable way to our right to keep and bear arms in the future. Let's talk about it all when we come right back. Hey folks, I'm Mark Smith, host of the Four Box and Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. And you know what I'm going to say if you've been watching me lately, which is you can vote for the 2026 Gundies Awards because I've been nominated to be the top voice of the 2A for 2026 to be announced in January. The voting is now, you get a say as to who is the top voice of the Second Amendment in America. If you go to the Gundies.com, vote for Four Boxes Diner or Mark Smith for the top voice of the 2A. You can do that once a day, every day, between now and December 15th, with the winner announced in Las Vegas right before SHOT Show at the Gundies in January, I think January 19th of next year. So if you're so willing, I would appreciate your support in the Gundies 2026 competition. Four Boxes Diner, top voice of the 2A. All right, folks, so I've been getting a lot of questions on social media about what's going on with the Missouri Second Amendment Preservation Act, which was enacted in 2021. It's been in the court system since then. The Joe Biden administration sued to enjoin the law. A three-judge panel in the United States Court of Appeals for the Eighth Circuit in the Midwest, that covered like Minnesota and Missouri, for example. The Eighth Circuit three-judge panel decided that indeed this Missouri sanctuary law, Second Amendment sanctuary law, Second Amendment Preservation Act, whatever you want to call it, did indeed violate the U.S. Constitution. Specifically, it said that it violated the federal Constitution's provision known as the Supremacy Law, or the Supremacy Clause, that says that if there's a conflict between federal law on the one hand and state law on the other hand, the federal law is supreme. The argument being that this Missouri state law was essentially an attempt, at least in part, to nullify and remove and void out federal law, federal gun control laws, which was not allowed under the Supremacy Clause of the United States Constitution. Now, to make a long story short, a three-judge panel from the Eighth Circuit, again, found this Missouri law to be unconstitutional under the Constitution, and they said it's not enforceable. In 2025, earlier this year, the state of Missouri, or Missouri, depending on where you're from in the state, filed a petition for cert to the U.S. Supreme Court, asking the Supreme Court to hear this case, essentially to address certain issues of the 10th Amendment, states' rights, federalism concerns, some other issues in terms of the way to interpret the Missouri Preservation Act, dealing with what's known as the anti-commandeering law, which we'll get to in a moment. And basically, the U.S. Department of Justice, which had just flipped over from the Biden administration to the Trump administration, essentially took the position that says, look, Supreme Court, we agree that actually, this is kind of interesting, by the way, that the Trump DOJ admitted to the U.S. Supreme Court when they defended the law in a sense. And what I mean by that is they basically defended the Eighth Circuit decision in part and said, look, Supreme Court, we actually agree. This is what the DOJ said under Trump. We actually agree, frankly, that the U.S. Court of Appeals for the Eighth Circuit, in finding this Missouri law, was unconstitutional in its entirety. We at the Department of Justice, now that we've transitioned from the Biden years to the Trump years, we actually think that Missouri may have some okay arguments here. And we actually think at the Department of Justice that the three-judge panel in the Eighth Circuit Court of Appeals out of Missouri may very well have gotten its decision in part wrong. And as a consequence, U.S. Supreme Court, we think you should deny cert in this appeal, if you will, this request to hear the case from the state of Missouri. We, the Department of Justice, think you should deny cert and send the case back down for what we would consider to be a potential modification of the judgment, because we at the Department of Justice do agree that the Eighth Circuit may not have fully appreciated some arguments here. And therefore, we would be open to a discussion with the state of Missouri about allowing some of its state law, some of its Second Amendment Preservation Act law to continue in effect, whilst those parts of the law that really violate federal law would have to be enjoined and not enforced. And that's kind of what the Department of Justice said. And then the U.S. Supreme Court denied cert, which, by the way, I wasn't surprised. I didn't even cover this particular case because I try on this channel to really only cover the issues that I think you really got to know about, that I really think are real, meaning something that's meaningful, that's going to actually matter, that the Supreme Court's actually going to act upon. And I did not deal with this, not because I don't support Missouri and I don't support their efforts to try to undercut federal gun control laws. I generally do. But the reason why I didn't really cover this is because I thought the odds of the U.S. Supreme Court here in this case was basically 0%. And the reason why is it didn't meet any of the criteria that the Supreme Court would apply and find that a case merits being heard on the merits at the Supreme Court level. Number one, there's no circuit split between the different courts across the country as to whether or not this law is, or anything like this law, is constitutional. This is kind of an outlier law, a one-off law in Missouri. No other state really has an analogous law like this. So, if they made a decision in this case by the U.S. Supreme Court, it really would only apply to Missouri. It really wouldn't teach Americans a lot about federal law generally. It would not have wide application to all 50 states. And again, it's kind of an outlier law and kind of a weird issue about what's known as anti-commandeering, which we'll get to in 1 second. And really, I think the Supreme Court just said, yeah, this is just, we got so many other things we have to take. We got 70 cases a year we take or so. We're just not going to devote a slot to this case. It's just not a big enough deal. So the Supreme Court denied cert. But the good news is that the DOJ has at least indicated they're willing to consider allowing parts of this law to go into effect. Now, how to understand this Missouri Second Amendment Preservation Act, the good and the bad and the ugly of it. Now, I'm not going to belabor all the details and go provision by provision by provision. But the bottom line is there is one thing that I think everyone agrees, including the Trump Department of Justice, the U.S. Supreme Court, the Missouri legislatures that enacted this. And that is under the longstanding doctrine known as the anti-commandeering law or the anti-commandeering doctrine. Means what? The anti-commandeering doctrine basically says that a state official has no obligation or duty to cooperate or assist the federal government or federal law enforcement enforce federal law. Meaning that a state official in Missouri could refuse to help the federal government enforce federal gun control laws. Under the anti-commandeering doctrine, meaning that the federal government is not allowed to commandeer or take over or control state officials in a state like Missouri, that's the anti-commandeering doctrine. As a consequence, basically, the Department of Justice under Joe Biden or under Donald Trump, for that matter, could not go to Missouri and say, you, Attorney General of Missouri, you, St. Louis police officer, you, police officer in Kansas City. That's right. The federal government under the anti-commandeering doctrine has no right or authority to go to a state actor and force them to cooperate and help the federal government enforce federal law. Now, with that said, a state official in Missouri or otherwise is not allowed to act in a way that undercuts federal law, meaning they're not allowed to interfere with federal law. See the difference? They don't have to help enforce federal law. They can be like, hey, you want to arrest the guy? You arrest the guy. I'm not touching this. I'm not involved, for example. Or, hey, we came across a potential federal gun crime here on our docket or on our case, on our desk, whatever it is. we don't have to call up the DOJ or the U.S. Attorney's Office and say, hey, we think there's a violation of federal gun control law here. They don't have to make the call and report the issue to the feds. They can just not do it. They can just ignore it. They can do that legally because of the anti-commandeering doctrine, again, preventing the federal government from commandeering state resources and state employees to do the feds' bidding. With that said, they're not allowed to undercut federal law, meaning if the federal law enforcement officers are driving down the street to arrest, let's say, illegal immigrants, or to arrest gang members over a violation of a federal gun control law, state officials in Missouri or other states are not allowed to, let's say, jump into the roadway or block the road on purpose to thwart the federal law enforcement agencies from doing their job. That would be actively undercutting or actively interfering with federal law enforcement efforts, and that is not allowed. That is not allowed. They're not allowed to help. They're not allowed to actively undercut or actively interfere with federal law enforcement. So what is the problem here, and what should we be worried about? Because people have been asking me about this, and I'm a little perplexed about why this is an issue right now. Because if I could wave a magic wand and I were in the Missouri legislature, I would simply go down two paths here. Number one is I would instruct the Missouri Attorney General and the lawyers handling this case from Missouri to go back to the United States District Court for the Western District of Missouri, which is where this case kind of arose from. That was the initial trial court. And I would try to restructure the final judgment in such a way that would allow the vast majority of the law to go into effect and not be enjoined. I would try to cut that deal with the DOJ, emphasizing what the DOJ has already admitted, which is they cannot make the state of Missouri, they cannot make the state of Missouri help the feds enforce federal gun control law. And that would be the first step I do. The second thing I would do is the Missouri legislature could enact a new updated law that narrows the scope of the statute to make it crystal clear that nothing they're saying in the statute is designed to interfere with federal gun control laws. They can express their concerns about the constitutionality of them, they could say, but they just got to make it clear with their language that nothing about this statute should be interpreted as saying that we think we, the state of Missouri, are superior to, or that this law is superior to the United States Constitution Supremacy Clause, which says that federal law trumps state law, federal court decisions trump state court decisions, and so on and so on. And make it clear that that's not what they're doing. And by the way, when I read the Eighth Circuit decision in this case of United States versus Missouri, I did not think the three-judge panel came across as particularly smart, and I'm not particularly shocked. I mean, the one judge in the U.S. Court of Appeals for the Eighth Circuit that's like a superstar is David Strauss, former Clarence Thomas clerk, a shortlister to sit on the United States Supreme Court. He's had some very good decisions on a lot of different areas, including the Second Amendment. And outside of Judge Strauss, I find the bulk of the Eighth Circuit judges in the middle of the country to be very ordinary, and I don't mean that in intellectually or anything. I'm just saying I think they're very institutionalist. They're kind of milquetoasty. They're kind of like squishy types. They're not hardcore judges. They're not to be confused with a Judge James Ho out of the Fifth Circuit, or a Judge Greg Katsas out of the D.C. Court of Appeals, or a Judge Lawrence Van Dyke out of the Ninth Circuit there in Nevada and California and whatnot. The Eighth Circuit doesn't really have those kinds of judges. So, reading this opinion in this case, I kind of thought that the reasoning was a little loose, very favorable to the federal government, and probably not as intellectually sharp as it could have been. And I looked at the judges. I'm like, I kind of see it. Judge Dave Strauss from Minnesota is not on the panel. I looked at the people that were on the three-judge panel, the judges. And I'm like, I could kind of see them kind of muddling their way through this and not being precise enough. And again, what's interesting is that the U.S. Department of Justice under Donald Trump and Pam Bondi literally flagged this. Here's what they had to say about the Eighth Circuit opinion. It's kind of embarrassing for the Eighth Circuit, and I'm not shocked they said this. Actually, I'm kind of shocked they said this, but I'm not shocked that this is what they're thinking. Here's what the Department of Justice had to say kind of criticizing the Eighth Circuit decision in favor of Missouri, believe it or not. Here's what they wrote in their opposition to cert to the U.S. Supreme Court itself. While Missouri's objections are flawed, the constitutionality of some of the Missouri Act's provisions raises more difficult questions than, listen to this, folks, than the Eighth Circuit recognized. And following the change in administration, the United States has decided it no longer wishes to challenge those provisions in this pre-enforcement posture. Did you hear what that says? They literally said that there's provisions that the federal government will not enforce out of this Missouri Act. Then the DOJ brief goes on to say as follows. All that said, having reevaluated this case, the United States government, meaning the U.S. Department of Justice, has concerns about whether the judgment below extends too far and enjoins applications of the Missouri Act that do constitute mere non-enforcement of federal law protected under the anti-commandeering doctrine. And those concerns are exacerbated by the uncertainty in this pre-enforcement posture about how certain provisions of the Act will be applied and about whether the provision on which the Eighth Circuit focused is indeed inseparable from the rest of the Act. So there you have it. Based upon what the Department of Justice under Pam Bondi and Donald Trump are saying here, is that they seem to be willing to go back and modify the judgment to allow aspects of the Missouri Second Amendment Preservation Act to go into effect, which is clearly the right answer, by the way, because there's nothing that the federal government can do to force state officials in Missouri to cooperate and aid and abet in the enforcement of federal gun control laws. With that said, do I think the Missouri statute maybe went too far, thereby giving the hook to the Biden Department of Justice to attack and knock it out, and allowing kind of a very milquetoasty 3-judge panel in the 8th Circuit in the middle of the country to kind of go along with it? Yeah, I think maybe a little bit crisper drafting by the Missouri legislature here to avoid those potential problems in court might have been a good idea. But again, it can go back and be fixed now, either by a modification of the judgment after negotiating with the Department of Justice. I don't know if that's doable. I don't represent Missouri. I can't speak to that, but I would think that's something that could be done. Or alternatively, for the Missouri legislature simply to modify the law and narrow it down and cut out those aspects of the federal law that allow for a federal court to have a hook to declare parts of this Missouri Second Amendment Preservation Act law to be unconstitutional, which again, I think there's aspects of this law that are clearly constitutional, and there's nothing requiring Missouri from helping the feds enforce what they view to be as unconstitutional federal gun control laws. So anyway, folks, I hope this clarified some of these issues that I've been asked about on social media. Again, if there's other specific questions, feel free to ask them in the comments below. I'll try to comment and respond. So with that said, I hope you enjoyed today's episode. Make sure you follow me over there on X at @4boxesdiner. Don't forget to subscribe both to YouTube and to Rumble. And I look forward to talking again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.